Do all heirs have to agree to sell property inherited in Georgia? When multiple heirs inherit property in Georgia, the question of whether all heirs must agree to sell often arises. Selling inherited property can be complicated, particularly when emotions and differing financial goals come into play. Understanding Georgia's legal requirements is crucial for ensuring a smooth transaction, especially when unanimous consent among heirs is hard to achieve. Legalities surrounding inherited property in Georgia, the rights associated with inherited property are governed by intestate succession laws. These laws outline who inherits property when someone dies without a will and how decisions are made regarding the sale or retention of that property. Heirs typically hold the property as tenants in common, meaning each heir has an undivided interest in the entire property. If all heirs agree, selling the property is straightforward. However, unanimous consent is required not only for the decision to sell but also for details such as the sale price and distribution of proceeds. Disagreements can lead to legal disputes, which may require court intervention through actions like a partition sale. In such cases, the court can order the sale of the property, ensuring all heirs receive their fair share of the proceeds. Additionally, the Uniform Partition of Heirs Property Act, UPHPA, provides a mechanism for resolving disputes. Under UPHPA, heirs who want to sell the property can be bought out by those who prefer to keep it, ensuring a fair resolution without forcing a sale. Do all heirs have to agree to sell? Yes, all heirs generally must agree to sell inherited property in Georgia. This is because each heir has an interest in the property, and selling it affects everyone's stake. Without unanimous consent, the sale cannot proceed. If one heir wants to keep the property while others wish to sell, those wishing to keep it must buy out the others. However, when consensus cannot be reached, legal options like a partition action become available. A partition action is a lawsuit where the court steps in to resolve the disagreement by either forcing a sale or dividing the property among the heirs. This process ensures a fair outcome for all involved, but it is often a last resort when negotiations fail. The process of selling inherited property in Georgia. The process of selling inherited property begins with determining how many heirs there are and what share of the property each heir owns. Once this is established, the following steps are involved. Unanimous consent. All heirs must agree to the sale and the terms, including the sale price and how proceeds will be divided. Partition action. If an agreement cannot be reached, any heir can file a partition action. The court will then either order the property to be sold or divided, depending on the circumstances. Buyout options. Heirs who do not want to sell can offer to buy out the shares of the other heirs. The value of each share is determined by an appraisal. Closing and distribution. Once the property is sold, the proceeds are distributed according to each heir's share. Any disagreements about how the proceeds should be divided must be resolved before the sale can proceed. Understanding these steps helps heirs navigate the process while minimizing conflicts and delays. If you're facing the challenge of selling inherited property and struggling to reach unanimous agreement among heirs, Trace Brooks Law can help. Our experienced probate lawyers can guide you through Georgia's inheritance laws, protect your rights, and resolve disputes. Contact Trace Brooks Law today at 404-492-9559 or visit us at 1275 Peachtree Street, Nebraska number 525, Atlanta, Georgia, 30309 for professional legal assistance with your inherited property concerns.